New tonight, we're listening to your voice. A viewer sent us an email about new HOA rules that are about to take effect. Did you know more than 9 million people, or nearly 45% of Floridians, live in communities governed by homeowners associations, and they can regulate what kinds of vehicles can park in their communities and where they can park as well. But a new state law going into effect on July 1st says HOAs can no longer pass regulations preventing pickup trucks and work trucks from parking in driveways. As I-Team investigator Adam Walser has learned, it's still unclear how this new law will be applied.
With more than 42,000 residents, Lakewood Ranch is one of the fastest growing planned communities in the United States. Golf courses, a polo field, and palm tree lined streets cover 31,000 acres in Manatee and Sarasota counties.
You can see that, in this kind of a neighborhood, homes are, very small lots.
Mike Miller, a former Lakewood Ranch board member, bought there in 1995. He believes HOA rules help preserve his neighborhood's look and property values.
I think people kind of select a community in part because, how it hits them as first impressions.
Plenty of people drive work trucks in Lakewood Ranch during the day, including Prisco Solis, who we saw supervising a roof installation.
I don't usually go to the office, so I'm always out and about.
Solis relies on a take-home truck, which he parks in his driveway in a different neighborhood. So do tens of thousands of other Tampa Bay residents, including painters, plumbers, cops, carpenters, and others, whose HOAs don't prohibit commercial vehicles in driveways.
You have to pay for the HOA somehow. How are you going to get to your job if you don't have a vehicle?
But commercial trucks aren't allowed to park overnight in Lakewood Ranch.
It would change the look of the neighborhood to have those kinds of vehicles in, multiple places.
Currently, even pickup trucks are prohibited under the rules.
It's not uncommon that people come in with a pickup truck and say, wait a minute, I didn't really understand that I'm not going to be able to keep my truck. Isn't there a way I can work around this? So far there hasn't been, but people find their accommodations in terms of how they deal with it.
So they're going to try to either put that truck in the garage or
sell it, or park it someplace else.
That all could change July 1st when a new state law goes into effect that says homeowners association documents, including declarations of covenants, articles of incorporation, or bylaws, may not preclude a property owner or a tenant, a guest, or an invitee from parking his or her personal vehicle, including a pickup truck, in the property owner's driveway. Miller worries that could mean anything goes.
It says vehicle. So it could be an RV, could be a bus, it could be anything that somebody drives and considers to be their personal vehicle.
That could include this, or even this.
Could be a monster truck.
As long as it has 2 axles and weighs under 26,000 pounds.
The community really loses all control and ability to manage themselves.
We've had a number of calls with this.
Attorney Jonathan Ellis says the wording of the new law is vague, and it's not clear whether it applies to existing HOA rules.
The general consensus from the lawyers that I've spoken to is it's very questionable whether you could actually apply this retroactive. And even if they did want to make it apply retroactive, it's a question of whether the Florida Constitution would allow it to apply retroactive.
So it sounds like this is about as clear as mud.
Over the next few years, this is going to make its way, what I always call, through the trial courts. It's not clear every judge is going to rule the same way on this.
And in civil court, the losing party often has to pay both parties legal fees.
And this now raises the stakes, both for the association and for the unit owner, on whether they want to challenge it and at what level they want to challenge it.
Ellis expects how the law will be applied will be decided by an appeals court or the state Supreme Court. Or lawmakers may even have to revise the statute altogether to make it clearer. Miller doesn't yet know how it will all play out in Lakewood Ranch.
It just opens Pandora's box, right? That's the biggest problem. It's you don't know what's going to happen next.
The new law is expected to be good for at least one business.
This vagueness could create a lot of work for a lot of lawyers.
It creates a lot of work.
I'm I-Team investigator Adam Walser with photojournalist Matt McGlashan, taking action for you.